When a routine court session ended in Greenwood County, Kansas, no one expected the cameras would capture a confrontation that would test the boundaries of prosecutorial power and judicial authority. What started as a simple administrative discussion exploded into a legal battle over who holds the upper hand in the courtroom and whether anyone is truly above the law. In the Greenwood County Magistrate Court located in Eureka, Kansas, Judge Phyllis Webster and County Attorney Jill Gillette remained after the day's proceedings had concluded. The courtroom cameras continued recording as they reviewed cases involving multiple defendants who had missed their required court appearances. As Judge Webster examined the files, she uncovered a significant administrative breakdown. Critical documentation was missing, rendering her powerless to enforce consequences against those who failed to show up. Her observations suggested the county attorney's office might bear responsibility for this oversight. What followed was County Attorney Gillette's reaction, a response so inflammatory it threatened to derail her professional standing.
We have to brought it up to you. I'm not going to argue with you.
And
Just
Tanya Sanchez.
we already did Sanchez. We have a Tiana Richardson and a Dustin Newport. I still have.
Well, hold on. That's not what I'm showing. What do you have, Missy?
I have Alfonso Caldwell and Tiana Richardson. That Newport bonded out, or no, well, he bonded on ours, and then Lyon County come and got him
I
before.
noticed, okay, he was taken off the docket. And what did I do? Mix up Tanya Richardson and Sanchez?
Mm-hmm.
And no one mentioned that I was using the wrong name?
You were using the right name.
Mm-hmm.
Oh, okay. Okay, well, and these are my couple that I don't have anything filed to show that they have to be in court. I don't have a summons. I don't have a uniform notice to appear issued by the officer in the ticket.
Judge, the girls filed the ticket earlier today.
Okay, let me see if it's, maybe I just need to double check. Mr. Caldwell.
Mm-hmm. Tickets were issued January 23rd, 25 at 20:59 hours. But
Okay,
today,
well, let me make sure they made it to the file because I'm not seeing that. I don't see that, Miss Gillette, and until I have filed verification that they had noticed this hearing. I'm not finding that. Missy, do you have that where you can look at it? Because I am not seeing it filed. Maybe I need to. No, I think I've already refreshed to see if they've been added. You want to
They're
check?
not in the case yet.
What was that, Missy?
I said they're not. They're not showing up in the case yet.
I don't know if upstairs hasn't approved them or what's going on.
I can check.
Would you check? We'll take just a real quick recess because I don't have anything in the file to show they have notice of the hearing, so I can't take any action for their failure to appear without it.
Judge Webster maintained she lacked the legal foundation to proceed against the absent defendants because their files contained no proof they'd been properly notified of their court obligations. The law typically grants judges considerable power when defendants deliberately skip scheduled appearances. They can issue bench warrants leading to immediate arrest. Kansas Statute 19-4730 specifically empowers judges to charge individuals accused of county code violations with contempt and authorize their arrest through bench warrant when they don't appear. But there's a critical prerequisite embedded in this statute. These judicial powers activate only when defendants fail to appear after service of notice to appear. A direct quote from the legal text. While the specific allegations against these no-show defendants remain unknown, establishing that proper notice was delivered stands as an indispensable element in demonstrating willful non-compliance. Judge Webster's insistence on documented evidence before wielding her authority against citizens wasn't just reasonable, it was legally sound and ethically necessary.
Arlene's going to bring the unfiled copy upstairs, Your Honor, but they were submitted this morning by Jessica.
They haven't made it into the file for some reason. Well, I need I need the originals. You're thinking the originals are on file somewhere or waiting to be filed? See what Missy finds. Maybe they'll find the originals at the clerk's.
What, Judge? I'm sorry, I'm back now.
Well, she said they'll bring up, if I understood Miss Gillette right, they're bringing up copies, but where are the originals?
I think I actually have a copy because I was asking them today about it, so
Well, I
I
need,
can print you off the copies that I got
now
sent.
copies, I need original documentation that these people had notice of this hearing, either in the form of a returned summons or a citation. And I don't have one of anything to show that they know about this hearing today.
Your Honor, the citations, we get a Xerox of them. We don't get the originals. The originals normally stay either in the file with the sheriff's office now, or they go straight upstairs. But this had to be long formed because it's marijuana. And so
Well, even with the long form, I would accept, you don't have the originals, Arlene? What do you have? You have copies? Have those been filed with the clerk?
Yes.
They have been filed. They didn't make it into their file. Do you know why? I don't have them in the file.
Well, because that's the clerks.
Okay. Well, Missy, did you check with the clerks?
Yes, I just checked with them and they have not been, they do not have them. They're not in the queue to approve.
I know they're not in the queue. I looked through the queue. Oh, unless you mean their queue.
Yeah,
Well,
they're,
what I'm going to do, now I'm looking at copies of tickets. And I've seen enough tickets over the years to know these are tickets, and they do appear to be signed by the signature I know as Blake Fisher's, although I'm not an expert in handwriting. But I am not comfortable issuing any kind of failure to appear warrants if there's no documentation in the file. These are just handed to me, but once they are filed, then I would not hesitate to issue warrants for their failures to appear. So I'm going to set these two cases over till next Tuesday. By then, I'm sure that we'll figure out why those haven't been filed. And then if they're not here at that date and time, we'll issue warrants. But they'll have to be given notice of the new date and time. And it looks like they're out of Wichita, Kansas. Yes, so
if I have to issue new summonses, then it's going to be more than a week because I have to issue them, send them to Wichita, and have them served on them. They have their notices to appear, complaints.
all right, I'll tell you what, I don't.
I don't even get the original anymore.
Just file the copies, whatever, but they have to be filed, Miss Gillette. I have nothing that gives me legal authority to issue failure to appear warrants. I have in the file, and I'm looking at it, a complaint, a probable cause affidavit, a notice that you're going to rely on KBI reports, and that's it. There is nothing in the file to show legally that they have notice of this hearing. So I don't know where the tickets are. I don't know why they're not filed. I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. So in fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. Get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant. And you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
My secretary is not the clerk of the district court. My secretary is not the custodian for that. They
We
have to be
brought a copy
filed.
up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Miss
We are-
Gillette, you are not listening to me. And you're being contemptuous.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will
You
file.
have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
Judge, I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
Ms. Gillette asserted that prosecutors possess immunity from contempt charges. Judge Webster countered by emphasizing that attorneys carry ethical responsibilities that transcend such protection. The legal foundation for prosecutorial immunity traces back to the Supreme Court's 1976 decision in Imbler versus Pockman, which established that state prosecutors performing their official duties, initiating cases, and pursuing criminal charges enjoy absolute immunity from civil damage lawsuits. The court's reasoning acknowledged an uncomfortable reality. To be sure, this immunity does leave the genuinely wrong defendant without civil redress against a prosecutor whose malicious or dishonest action deprives him of liberty. But the alternative of qualifying a prosecutor's immunity would disserve the broader public interest. It would prevent the vigorous and fearless performance of the prosecutor's duty. It's essential to the proper functioning of the criminal justice system. Yet there's a crucial distinction to recognize. Protection from civil litigation, which shields prosecutors from lawsuits filed by defendants claiming wrongful charges, doesn't logically extend to shielding them from judicial contempt findings based on courtroom misconduct. Kansas Statute 20-1203 grants judges authority to sanction anyone for direct contempt, which Statute 20-1202 defines as contemptuous acts committed during the sitting of the court or of a judge at chambers in its or his presence. The statutory language contains no carve-out exempting prosecutors from this judicial power. Legal precedent consistently affirms that judges possess authority to hold attorneys accountable through contempt citations for inappropriate behavior. Consider the 1877 Kansas Supreme Court decision in re Pryor, which established that attorneys can face contempt punishment for insulting or disrespectful language or conduct in the presence of the court. The court emphasized that attorneys bear special duties. An attorney is under special obligations to be considerate and respectful in his conduct and communications to a judge. He is an officer of the court, and it is therefore his duty to uphold its honor and dignity. The independence of the profession carries with it the right freely to challenge, criticize, and condemn all matters and things under review and in evidence. But with this privilege goes the corresponding obligation of constant courtesy and respect toward the tribunal which the proceedings are pending. A failure to extend this courteous and respectful treatment is a failure of duty. It may be so gross a dereliction as to warrant the exercise of the power to punish for contempt. My research uncovered no case law supporting Ms. Gillette's claim of prosecutorial immunity from contempt. However, she did mention having briefed the matter, suggesting she possesses some legal analysis defending her position. I'm genuinely curious to examine this brief and understand the legal reasoning behind her argument. Even assuming Kansas prosecutors do enjoy contempt immunity, Judge Webster correctly noted that attorneys remain bound by ethical standards governing courtroom conduct, violations of which can trigger professional sanctions. Kansas rules of professional conduct, specifically Rule 3.5d, states, "A lawyer shall not engage in undignified or discourteous conduct degrading to a tribunal," meaning the court itself. Consequently, Ms. Gillette's behavior toward Judge Webster potentially exposed her to disciplinary action for breaching professional conduct rules.
At this time, Missy, it looks like Ms. Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated, but for now, we will be in recess.
Judge, I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Miss Gillette.
Whether Ms. Gillette ultimately faced professional consequences remains unclear, though she has subsequently appeared before Judge Webster without apparent friction. This episode illuminates an important principle. While prosecutors enjoy certain immunities, they aren't shielded from accountability when acting improperly, and they must respect the procedural framework of our judicial system. Just like every other participant, Judge Webster deserves recognition for refusing to authorize citizen arrests without confirmed legal authority. Despite likely trusting the accuracy of Ms. Gillette's information, she insisted the prosecution complete proper administrative procedures before moving forward with warrants, applying the same standard to government officials that she would to private citizens. One heated moment shouldn't define Ms. Gillette's professional identity, and nothing here suggests she lacks competence or qualifications for her position as county attorney. Administrative mistakes create frustration in every profession. While that doesn't excuse her outburst, it serves as a reminder that we've all experienced similar pressure, and nobody is immune to difficult moments at work. This case raises fundamental questions about accountability in our justice system. When you see moments like these, what concerns you most? Procedural errors that could impact citizens' rights, or the human element of professionals working under intense pressure? Share your perspective in the comments. Subscribe to join a community committed to transparency and understanding in our legal system, because an informed public is the foundation of justice.